When you know Toby Cadman very well, you don't need an introduction. First, he will give some statement, and after that, you can ask a question. So now I will request Toby Cadman to give him a briefing and then give us question.
Thank you very much. I prepared actually two written statements that will be made available to you all after this press conference. One of them is a statement, a general statement on the proceedings at the International Crimes Tribunal in Bangladesh generally, and the second statement is an open letter to the Honourable Foreign Minister Dip29 regarding a statement that she made in relation to my conduct, the statement that she made on the 18th of December. I issued a short press statement after her remarks at the Birmingham City Council. This letter is an open letter to the Honourable Minister requesting that she withdraw her statement and issue an apology. In relation to the general remarks that I'd like to make, I'm going to keep my remarks brief to enable you sufficient time to ask questions. The main reason for agreeing to meet with you is to give you an opportunity to ask me whatever questions you may feel is necessary. I would only say I cannot comment on the individual cases. I would like to comment on the matters that have become very public over the last few weeks, because these matters affect the credibility of the tribunal and what happens from here. The first thing that I'd like to state is I have been accused of many things, of thwarting the trials, of coordinating a conspiracy. I reject such statements as utter nonsense. I'm engaged to represent a number of individuals who face trial. My role is to represent them and to ensure that they have a fair trial. And if I do not consider that they're getting a fair trial, I will say so, and I will say so publicly. I defend completely and entirely all the statements and all the remarks that I've made. And I'm now deeply concerned as to the way forward and what the national and international community should do in response to the allegations that have now been made. These allegations are very serious because they go to the very core of this whole process. But the first thing that we should all remind ourselves is that there should be a judicial process. I have always stated that there should be a judicial process and there should be an end to impunity. But that means impunity from the crimes committed in 1971, which no one can deny, and that only those who bear ultimate responsibility for those crimes should be put on trial by an independent and impartial tribunal of law. The question now is whether those who are facing trial can receive a fair trial in light of the allegations that have been made. As you will note, following the resignation of the former chairman, a replacement has now been appointed, and the government has made a number of statements that the trials can now continue where the chairman left off. My view on that statement is that that is nonsense. There has to be a full, independent, impartial inquiry as to how far these allegations go, as to whether it concerns other judges. The recordings that many of you will have seen concern at least the chairman of the tribunal, the former chairman, at least one prosecutor, two government ministers, and an organisation called the International Crime Strategy Forum that has been providing, as it would appear, assistance to the chairman. One of the questions that has been raised, or one of the responses issued by the government, is that it is perfectly acceptable for a judge to have an advisor. I completely agree with that. I once served as a judicial advisor myself. in a court in Bosnia. But it was open and transparent, the advice that I gave. And I would sit in court with the judges. If it is acceptable for the former chairman to have consulted Dr. Ziuddin as his advisor, one must ask the question why he initially denied the existence of such a relationship. But the relationship, it would seem, and I'm making no determination other than the publications that have been made, but the relationship would appear to go further than that of a judicial advisor. It goes so much further. And in that regard, I would just like to read out a couple of remarks. The material exposed in the media thus far makes the following general allegations, and I repeat, they are allegations, and that is why there needs to be a full and independent inquiry. I consider that the inquiry should be conducted by an international body, and I will say so, I will state my reasons for that once I've just read out this short list of elements of, that have been covered by the publications. 1. It has been shown that Dr. Ziuddin has been advising on and drafting judgments, orders and decisions for specific cases which were used with minimal amendment by the chairman. That would appear to go further than just mere advice. Advising the chairman on suitable judges and those that should be replaced due to their unwillingness to conform. Meeting and having detailed discussions with key prosecution witnesses to prepare them for their testimony. And it should be remembered that this amounts, if established, to subordinating perjury. Interacting with members of the prosecution to provide them with information in relation to witnesses and other legal issues. Instructing, pressuring members of the prosecution to align prosecution witness testimony with the chairman's request for evidence upon which he may take judicial notice. Advising the chairman on strategic decisions. Discussions which reflect inherent bias of the chairman, where he informs Dr. Ziuddin that he will reject a defence petition before even having read it. The communications further reveal that to Dr. Ziuddin that he prefers his fellow judges to be compliant yes men. That is from the chairman. And an incentive for the chairman to deliver guilty verdicts in the 3 big cases before the first tribunal, and if he did so, he would be quickly promoted to the appellate division of the Supreme Court. Now, those are very serious allegations. Those are allegations that affect members of the government, members of the tribunal, and members of the prosecution witnesses, and civil society. The question of whether it's appropriate for Dr. Ziuddin also has to be looked at in the context of his relationship with the institute that he has in Brussels, his Genocide Institute, and his relationship with the International Crime Strategy Forum. Because when one acts as a judicial advisor, his bias has to be considered. As an individual who collaborates with 2 civil society institutes that aims at bringing these trials to conclusion, it would seem to the objective observer that he is biased and that he could not possibly give impartial advice to the chairman. Again, I return to the initial statement. There is nothing wrong with a judge having advisors as long as he is independent, impartial, and it is open and transparent. And I will repeat the remarks that I made last week when I was in London, that on one of my first visits to Bangladesh, I met the chairman of the tribunal and his 2 colleagues and the registrar, and I made it quite clear that my advice from my experience of having spent several years in the prosecution in Bosnia was that they needed to have additional support. They needed to have experienced advisors to assist them in their work. I made that quite clear also to the law minister. My reaction, or the reaction that I received from the judges, is that to request support from the government would have been to admit failure, and that was something that they weren't prepared to do. It's unfortunate that we've now reached this stage where the demand has to be for international intervention. I think all of you will agree that there must be a judicial process, that process must be aimed towards the victims of the armed conflict, and that has to be beyond reproach in order to close this painful chapter in Bangladesh's history. So that's what I would like to say. I'm quite happy to respond to any questions that you may have.
Whatever happened to the chairman of Tribunal 1, I'm not going to the process. I have seen some report in international media, including Wall Street Journal, Economist, Gulf News and Arab News. Especially in Gulf News, there is a report that apart from the judicial process, Islamic governments or leaders to convene a conference to resolve the crisis in political.
First of all, the matters that have been covered in the Congress with the Chief Judge had nothing to do with my visit to Saudi Arabia and well in advance of these disclosures. The government, that these trials are not proceeding in the right direction. These are not maintaining international standards. I don't believe they're actually maintaining national standards. What I had asked from the Gulf states is support in ensuring that this matter is put on the agenda of the United Nations Human Rights Council at their session in March, with a view to issuing a resolution or adopting a resolution calling for a commission of inquiry. The conference to deal with this on a political level. I strongly believe that there should be a judicial process, but that judicial process, as I've said, has to meet certain standards, and currently it does not. Whatever discussions have taken place on a political level subsequent to that are not of my making.
To you, as you know, this attorneys from abroad, they are not allowed. How far this judgment or verdict will be acceptable to you? Is it acceptable or not? Number one. If it is not acceptable, what should be the reaction of attorneys like you in home and abroad?
I think the reaction that you've seen from a number of organisations, a number of legal organisations such as the International Bar Association, such as the Bar Human Rights Committee in the United Kingdom, have been individuals, has no real bearing on whether the judgment will be acceptable. In my view, the judgment will not be acceptable for reasons completely unrelated to my ability to enter Bangladesh or not. I have raised concerns regarding my inability to be able to represent these individuals, and my colleagues, my two other colleagues in the United Kingdom, are not permitted to enter Bangladesh either. But there are reasons for our inability to be able to appear in court. As you probably know, the Bar Council in Bangladesh issued a decision that no barrister, unless he's a citizen of Bangladesh, can appear before the tribunal. That's their decision. I don't agree with it, but that's their decision. It's a sovereign nation. It's an independent profession, so they have made that decision. I think it's incompatible with the tribunal's rules of procedure that allows for foreign counsel to appear for either the prosecution or the defence, and this should be considered a specialist tribunal, not an ordinary court within Bangladesh. But that's their decision that I have to live with. We've done our utmost to work with the Bangladeshi Council in preparing these trials, and I have to say that the defence team have done an admirable job in very difficult circumstances. These are very, very emotional cases. It's very difficult to appear as defence counsel in cases like this, not just in Bangladesh, but anywhere in the world. As you know, defence counsel come under attack because of the clients they represent. But there has to be a strong, independent legal profession in these cases, or these cases will have absolutely no meaning. But whether or not I accept the judgments, it will be more a question of whether the people of Bangladesh accept the judgments and whether the international community supports what the tribunal has done. I can't speak for the people of Bangladesh, but I can certainly say that the international community, on a general level, does not support the way in which these trials are heading.
Why the international community, particularly human rights group, are not vocal against this judgment? What's your opinion?
International have made statements. International Centre for Transitional Justice, which is based here in New York, has been critical of the process. And at one stage, they were providing assistance to the tribunal by taking the judges to visit international institutions in The Hague. They decided to stop providing support to the tribunal. Now, you will have to ask them why they decided to stop providing support to the tribunal. I can't answer for them. But there has been criticism. There has been an opinion adopted. There was an opinion adopted by the United Nations Working Group on Arbitrary Detention, and we expect different agencies within the United Nations to issue additional reports. So I don't think it's fair to say that they haven't been vocal. They perhaps haven't been vocal enough. But the question is, if they are more vocal, if they issue more reports, is the government of Bangladesh going to change its position? I can't answer that.
This tribunal is finally they claim that it's a tribunal of the crime against humanities. They are not saying anymore that the International War Crime Tribunal, and then there stands that International Crime Tribunal. It's a dilemma. What actually it is, in your knowledge, is that the tribunal against the international crimes, international war crime, or against the humanity? What actually they meant it, and what is your understanding?
As I told you last time, I have not and I will not ever refer to it as a kangaroo court.
Right.
I think that
was the design.
I think that's very disrespectful, no matter what my views on the tribunal and the professionals that work towards it are. I won't say no. In relation to whether it's a war crimes tribunal or a crimes against humanity tribunal, those are just semantics.
Or the crime tribunal.
First of all, when we talk about war crimes, generally, internationally, when we say war crimes, it's a very generic phrase to include war crimes, crimes against humanity, genocide, and other crimes under international law. So it doesn't really matter whether it's called a war crimes tribunal or a crimes against humanity tribunal. The question is whether it's an international tribunal. No, it's not. It's not an international tribunal.
So it doesn't fit the definition.
It's not an international tribunal because it's not founded under international law. There are not international judges and prosecutors. It's not been organised through an agreement with the United Nations, hasn't been imposed by the United Nations Security Council. It is a national tribunal, and it's the only reason it's called the International Crimes Tribunal is because it's a tribunal that adjudicates international crimes. Crimes that are penalised under international law, that are contained in the domestic legislation. So it is a national court that applies or adjudicates crimes that are penalised under international law. War crimes, crimes against humanity, genocide, and other crimes as prohibited. But as I have said in the past, the question is, can you really call it a national tribunal? And I don't think you can call it a national tribunal, because it doesn't apply ordinary national criminal procedural laws. There is no appeal through the ordinary judicial system. The constitutional amendments have removed fundamental rights that are applicable in other criminal cases. So for that reason, it's a specialist or a special tribunal. So I don't think you can really call it a national or an international tribunal. It's a special tribunal. It's not compatible with the Rome Statute. Now, it's slightly complicated whether it should be compatible with the Rome Statute or not. As a state party to the Rome Statute of the International Criminal Court, you would hope that a domestic court will apply the same level of standard that you would expect at the International Criminal Court. But the International Criminal Court has no jurisdiction over these cases, and that's something that everybody needs to understand. These cases can never go to the International Criminal Court. The International Criminal Court has no retrospective jurisdiction. It can only deal with those matters that fall within its jurisdiction since the Rome Statute was adopted. So, for that reason, it can't. But the point that I've made is that when you become a member of that international club, you should adhere to the same level of protection. And one of the examples that we have often given is, let's say, for example, that there are crimes that occur today in Bangladesh that amount to crimes against humanity, or crimes within the jurisdiction of the International Criminal Court. You could have two sets of proceedings taking place in the same tribunal, in different courtrooms, applying completely different standards. Because the trials dealing with crimes that occur now would have to comply with the International Criminal Court standards. So you would have one case proceeding in one courtroom under the procedures of the Rome Statute, adhering to international standards, and then you have the trial in the courtroom adjacent that is applying the 1973 Act and the Tribunal's Rules of Procedure under a practice that we consider that falls woefully below international standards. And of course, that presents a very difficult situation. So for that reason, we have requested that the government implements at least the rules of procedure or the standards upon which the Rome Statute are founded. The Vienna Convention, the International Covenant on Civil and Political Rights, and Bangladesh is a signatory to this agreement, which contains a number of human rights protections, many of which are contained in the Constitution, but are removed because of the 1st and the 15th Constitutional Amendments. Our group on arbitrary detention even made the point very clearly that the tribunal should amend its procedures to be in line with those standards. Those standards deal with basic fair trial guarantees, and our position has always been that these are not being respected.
That's it. So
some of those are contained in the written statement that I've given. But very, very briefly, there are aspects of the investigation. For example, when an accused person is interrogated in the absence of his counsel and in the absence of the nature and substance of the allegations against him, the lack of proper disclosure by the prosecution, the lack of independence and impartiality, the lack of time to prepare for a defence, the arbitrary limitation of the number of witnesses that an accused can call, the prevention or the limitation on cross-examining prosecution witnesses. These are all aspects that affect the fairness of proceedings in our view. And of course the most recent aspect is the conduct which has been set out in The Economist and Wall Street Journal relating to the conduct of the chairman in collaborating with Dr. Ziauddin and members of the prosecution, members of the government. Those are all aspects that affect the procedural fairness of these proceedings.
is there any
Mr. Cadman, I have
The main difference in Bosnia was that it was determined by the international community that because of the how fresh the wounds of the war were, that there needed to be international supervision in Bosnia. Now, this is completely separate to the Yugoslav tribunal that was in The Hague. This was a national court, but this was a national court with national laws that had international assistance, international judges working with national judges, international prosecutors working with national prosecutors. And my role was as advisor to the chief prosecutor. The legislation upon which this court was founded was based on the Rome Statute. There was the right of appealing to a higher authority. There was the right to take judicial review to the Constitutional Court. And there were the procedures were deemed to be fully in compliance with international standards. One of the main differences was that all of the trials were monitored by a reputable international organization, and when that body made recommendations for amending the law, then those recommendations carried a great deal of weight.
The tribunal in Bangladesh?
No.
And are you going? No?
It doesn't exist. No. If you're referring to filing a complaint with the International Criminal Court, now of course anyone can file a case against Bangladesh in the International Criminal Court, but that has to be alleging war crimes, crimes against humanity, or genocide. So this is a very, very different situation. You can of course file appeals with what they call the Special Procedures Branch at the United Nations body that's going to take over the trials. That's a body that can make recommendations to Bangladesh, not transferring those cases to international jurisdiction. All the international community can do is recommend, really recognises that it is heading down a very dangerous path here, and that it would be in the interest of the country, and it would be in the interest of justice for this to be an internationally supervised process.
Okay.
But I think if you read the statements that have been made, desire to continue to rush into judgment without proper regard for the criticisms that have been made. This is a very different situation that the government now has to deal with. It has to. There is only one judge sitting who was of the three original judges who were appointed as part of that trial panel. But he was transferred to Tribunal 2 and has now been returned to Tribunal 1. The situation you now have is there is not a single judge on that trial panel who has heard all the evidence. The question is, how can they possibly deliver a judgment in this case without having heard all of the evidence? We have, of course, petitioned the tribunal for retrials in Saidi, Ghulam Azam and Nizami for Tribunal 1, and we have also petitioned for the disqualification of the prosecutor Jer Al-Malud because of his involvement, or his possible involvement with the former chairman. But the question is, how can the tribunal now deliver a judgment where the allegation has been made this judgment was drafted long before the evidence was completed, and to be able to maintain any prospect of a fair trial?
Is there any possibility of having this drama bringing it to the international court? Is there any appellate division?
No. What we are calling for is an independent commission of inquiry to be ordered, or to be on the initiative of the United Nations, that there is a full inquiry is whether this should now be part of an international process. That the trials should be taken out of Bangladesh and put in an international tribunal. Ordinarily, I would be against something like this, because I strongly believe that justice delivered in the very communities where the crimes were committed is the best way to bring an end to impunity. In Bosnia, with an internationally supported national tribunal is the correct way forward. That process had international judges and prosecutors for a transitional period of time. That transitional period has now ended, and that tribunal in Bosnia is now entirely a national process. That would enable all sides to be able to see that justice is being delivered. But there is another question of whether there should be an international process. As everybody has repeatedly stated, the principal perpetrators were the 195 Pakistani prisoners. In order to put on trial those who are still alive, who are the principal perpetrators, that could relate to what party they represent, should be brought to justice. And that's certainly the statement and the request that I've been making for the last 2 years. This should be an international process so that all persons who engage in criminal conduct during the 9-month war are brought to justice.
Declared in a public meeting, he said 14 criminals will be hanged the coming year. And even though, including the Prime Minister, every day is campaigning that no one can stop.
If I can stop you there.
Okay, please.
The list of that portfolio for contempt has been initiated by Tribunal 2. So for that statement, I don't think it's appropriate that I comment, because that's a matter that the second tribunal is going to have to deal with. I know the statement that he's made. I haven't referred to it. It's now within the jurisdiction of the second tribunal to determine whether he should be charged with contempt. If he did make that statement, of course, it is arguably a contemptuous statement falling within the jurisdiction of the tribunal. But that's up to them to decide.
Even though the Prime Minister, every day,
Yes.
and some medias, they are campaigning, they are showing lot of evidences and stuff. What do you think? Will it create any interference to the trial?
Well, if I could just answer that, then come to the gentleman in the second row.
Yes, sir. They are committed crime or not? This is my question. They are committed crime or not?
And for that reason, I've always said there should be a judicial process, and those that are responsible should be brought before a competent tribunal, an independent impartial tribunal, and if found guilty, sentenced accordingly. I don't believe in the death penalty myself, but if that's the ultimate penalty, then that's what the tribunal will set. Crimes were committed. I have never ever said the crimes were not committed. I would have to be a fool to try and suggest that the crimes were not committed where the evidence is that whether we believe at the bottom end of 300,000 or the top end of 3 million, there was a huge amount of suffering, and so there has to be a judicial process. But that is why it has to be a credible process, because of people like yourself, in order to see justice. And I do not believe that you will see justice with this particular process. In relation to your question about the statements that have been made, it does impact on the fairness of proceedings when the government constantly makes remarks referring to the war criminals, making a predetermination. The Prime Minister herself just 2 days ago, I believe, said that they would receive exemplary punishment, prejudging the outcome. Not if convicted. Those that are convicted will receive exemplary punishment, but the war criminals on trial will receive exemplary punishment. This is interfering with what is supposed to be an independent and impartial process, and members of the government should stop interfering with this process. That judges should be appointed who are able to act independently and impartially, and let justice take its course. That's
Does it mean that you are losing, or the defendants are going to be executed in a short period of time?
I think if you read the statements that have been made, certainly towards the end of this year, over the last couple of months, there have been numerous statements that individuals will be executed. Initially, those statements were that people would be executed on the 16th of December. There was a desire to hang 3 individuals. There was a statement by, I believe, the Agriculture Minister, and if I have the wrong minister, I apologise, but one of the ministers stated that if they hang 1 or 2, the others will shut up. And so these are the kind of statements that you are receiving. The statement on summary execution is if a person is convicted after receiving after a trial that is in breach of fair trial standards, it amounts to summary execution. It's not a question of winning or losing. It's a question that the trial process has to be fair in order for a sentence to be a legitimate sentence, and it's as simple as that.